But today, Kevin Harlow Miller is going to present an excellent presentation. I'm going to leave that to Scott Hammer's Law to introduce Kevin. He is our event sponsor today, so we welcome and thank Scott Hammer's Law PC for sponsoring this great event. And I'm going to turn things over to Scott. And again, thank you everyone for joining us today, and thank you to Scott for sponsoring and Kevin for presenting today.
Very good. Thank you, Kyle. Appreciate that, and everyone who's in attendance. It's really my pleasure to introduce Kevin Harlow Miller as your speaker today. Kevin is an associate with my firm, and interestingly enough, Kevin and I both grew up in the same town in Southern California, but didn't know that until we joined forces here in Boulder. And it's been a fantastic relationship ever since. A little bit about Kevin. He spent 3 years as a program coordinator for a queer and transgender resource center in Southern California, developing programming and resources on issues like the Older Americans Act and its protections for LGBTQ elders. He has interned for the first openly gay congressman of color, Mark Takano. He served as a gender and sexuality liaison with CU, student government, during both law school as a primary point of contact, during law school as primary point of contact for both undergraduate and graduate students on issues of gender and sexuality. He served as a CU liaison and the Colorado LGBT Bar Association during law school. In 2018, he received the Summit Scholarship Award through the Colorado LGBT Bar Foundation. He spent just over 2 years as a faculty fellow with the American Indian Law Program at CU after law school, working on the implementation of UN Declaration on the Rights of Indigenous Peoples into domestic policy, which intersects with a variety of issues, including gender and sexuality. He now, as I indicated, works with me primarily in family law litigation and continues to be involved in advocacy work to the fullest extent possible. It is my absolute pleasure to present to you your speaker, Kevin.
Thank you to Scott and Kyle. I'm going to get my screen share started so we can get this going. Okay. So today's presentation, it's Advocacy Requires Allyship. It's hopefully going to guide people on how to be conscious in their representation of LGBTQ clients. You may find at times I use the term queer instead of LGBTQ. That is a habit because I, as indicated by Scott's introduction, spent a lot of time working on these issues in a more academic and high level area, and queer is, commonly used umbrella term. I know for many people there are still negative connotations with that term, so I do try to go for the more benign LGBTQ or LGBTQ+. As the agenda indicates, I'll be doing this introduction, and then I will move on to kind of a historical overview of identity as a spectrum, some different and common identity categories you may encounter, especially in Colorado, based on my personal experience. As I get through that, I'll move on to considerations for practitioners to keep in mind and touch on emerging considerations outside of Colorado, as well as some specific Colorado policies and resources. And then I will give a summary and address any questions that come through the chat. As an introduction, the current state of policy and sentiment on LGBTQ issues has been flagged as very concerning by a variety of different organizations. Anti-LGBTQ hate crimes have been rising at an alarming rate over the past say 6 to 7 years, we've seen the sharpest increase in quite a while. The Williams Institute out of the UCLA School of Law released a study this past December 2022 that found LGBTQ individuals are 9 times more likely than non-LGBTQ individuals to be victims of violent hate crimes. These increasing instances of hate crimes are not exclusive to the United States. BBC News did an entire report on the rise of similar hate crimes in Western Europe, August of last year, so just over a year ago. And the FBI has also released hate crime data tracking the increase between 2020 and 2021 that shows a fairly concerning and significant rise in hate crimes across all identity categories, but inclusive of some pretty significant increases with groups belonging to the LGBTQ community, like bisexual identified individuals. There's been an increase in anti-transgender hate crimes. And the Human Rights Campaign, which is an advocacy organization that endeavors to improve conditions for LGBTQ individuals generally and at the policy level, they issued a declaration of a state of emergency in the United States earlier this year, in fact. And this is just a portion of the chart they released. I will be giving Kyle supplemental materials that can be shared, and it will have the full chart and how to access the full report and guidebook that HRC put together. As you can see, Colorado is relatively progressive with respect to where we are policy-wise compared to other states. We have no legislation that falls under the bad category, and we do have legislation enacted that is within the realm of the good category. On top of that, we have an openly gay governor, Governor Polis, who has a really lengthy history in policy advocacy and funding advocacy. But even with that in mind, it has not even been a year since the Club Q shooting in Colorado Springs. And these are all things that impact and inform the way LGBTQ people navigate the world around them. And these are important things for legal practitioners to be cognizant of and to consider when they are representing clients within the LGBTQ spectrum or representing clients in dealing with issues that implicate some identity within that spectrum. Sorry, I have not used a PowerPoint in years, so I keep hitting the wrong buttons. One of the big topics at issue right now on a national level is the so-called anti-drag bans and other legislation being advanced by individual states to restrict or prohibit expressions of gender that deviate from a binary, binary being male or female, rather than a plenary category. So to just cover some of the more common gender identities and the spectrum they fall within. Cisgender is when the gender someone is assigned at birth, generally based on their sexual characteristics, so the sex organs, that matches their internal perception of their own gender, and it matches their general outward expression. So with respect to hairstyle, clothing, whether or not they wear makeup, those things are all strictly within the male-female binary, and they don't diverge from the sex assigned at birth. Another point on the spectrum is intersex, which is a catch-all term for a variety of different manifestations of physical, chromosomal, biological variances from the sexual binary. So this can include somebody who, rather than ovaries, has gonads internally. So this is not, strictly fitting within the gender binary, the sexual binary. And it can also apply to different chromosomal configurations, and is something that is often debated when people choose to bring biology into discussions over policy and gender. The next point that's on the spectrum is gender nonconforming. This is another catch-all term, and it generally describes behavior or chosen expressions that diverge from a person's gender and the traditional notions for that. So, this can be somebody who was female at birth, identifies as female, but insists on maintaining, more traditionally masculine hairstyle, wears more traditionally masculine clothing. This is distinct from the next point, gender non-binary, which is, it is often confused with gender non-conforming because people within the gender non-conforming and gender non-binary categories often overlap. But gender non-binary is when somebody's gender identity does not fit within the binary system, or it is more want to fluctuate. So some days somebody will feel more comfortable and self-assured in a more traditionally feminine outward expression, so clothing or hairstyle, and some days they find more comfort and security in something different. And this does fluctuate, it varies by person. And this is, the next stage on the spectrum before we get to transgender, which is also an umbrella term, but with a more narrow scope. So transgender individuals, generally speaking, have a gender identity that does not align with the sex they were assigned at birth. It can often be, a self-identity that fits within the binary system. So if somebody were assigned male at birth, as they mature, they feel more appropriate being referred to with female pronouns, having a female outward expression of the self. And within this, there is its own range. There are transgender individuals who will dress with a more, say, deliberate expression of their gender identity, but they do not pursue hormone therapy or any surgical intervention to affirm their gender. You also have people who do receive hormone therapy to affirm their gender, but do not want to or cannot afford to pursue surgical affirmation. And you have transgender individuals who seek both the hormonal and surgical affirmation. Identity is also a spectrum with respect to sexuality. You have people that fall within the asexual umbrella, which is when somebody experiences little to no desire or inclination for sexual activity with other individuals. This does not mean they necessarily have no interest in romantic relationships. That is its own place on the spectrum. The term is aromantic. And then we have heterosexual, which is broadly understood, but physical and emotional attraction to members of the opposite sex. Bisexual, which is in and of itself somewhat debated on how much of an umbrella term it is. Bisexual people are generally understood to be attracted to members of either binary sex. Within the community itself, there is debate over whether this includes attraction to gender non-binary individuals, transgender individuals. But for today's purposes, that's a bit beyond the scope, just to kind of let people know it's something to be cognizant of. Pansexual is attraction to others without limitation based on categories of sex or gender. And homosexual is traditionally understood as attraction to members of one's own sex. This has its own internal debate as the culture wars, so to speak, over gender have become really elevated at the national level. So these are all foundational things people should be aware of. I know there is, especially in the legal community, a desire to make things fit neatly within boxes so it's easy to recall, reference, remember. But, these are lived identities, they are messy, they are nuanced, and to the extent you are able to recognize that this is a spectrum rather than something that can be neatly filed, that will inform your ability to be a better advocate and legal representative. So to get to the, so to speak, meat and potatoes of this all, how is it relevant to law? So there is the obvious intersection of law and identity. I think any legal practitioner is aware that a lot of the progress that people have seen from the policy perspective has been rooted in the judiciary. Supreme Court challenges to things like prohibition on same-sex marriage. We've recently seen some employment law issues before the Supreme Court to address whether transgender identity is within the scope of a protected class as a sex-based discrimination issue. Within family law, it falls into a lot of different categories. There are considerations for adoption. Same-sex couples are more likely to raise an adopted child. Approximately 4% of adopted children nationally are raised by same-sex parents, and about 3% of foster children are placed with same-sex foster parents as of 2023. There are some high-level considerations with respect to this when you delve into the distinctions between states. There was some pretty significant inconsistencies in terms of the legality of same-sex adoption. I believe Mississippi was the last state to overturn its ban on same-sex adoption. That was in 2016. However, because adoption and fostering are separate issues, there are still 12 states that permit discrimination on the basis of sexuality in foster placement. And for some states, a lot of the way they have structured this is to outsource foster placement to religious organizations so that religious exemptions can be advanced to effectively prevent placement with same-sex couples. While this is not an issue per se in Colorado, for anybody who may end up outside of Colorado that practices family law, it's something they should be cognizant of. And if anybody has clients who are considering leaving, this is something that if they fall within the scope of identities that this might be an issue for, they should receive at least some baseline counsel on it so they know they'll need to speak to an expert within whatever state they want to move to. There are also issues with child custody considerations. This is an especially unclear issue when it comes to biases on IVF children. So for example, if same-sex couple were to have a child and only one contributes the genetic material or only one carries the child to term, how does the court delineate, that biological contribution from the psychological parentage of the non-biological parent? So these are, issues that are becoming somewhat more common as there have been, some major advancements made with respect to civil rights more generally and the more widespread acceptance of LGBTQ individuals in society. And another area that I personally feel is very important as a family law practitioner is relocation cases involving children. Obviously, if one parent wants to relocate to a state that is advancing regressive or discriminatory policies like Florida or Tennessee, how do we ensure that the court is adequately balancing that consideration in deciding whether it is safe or appropriate for the child to move, whether it's in their best interest? When we look at criminal law, there is a big consideration with respect to incarceration and placement among prison populations. Colorado a few years ago had a lengthy lawsuit. I do not recall offhand if it is still going, but there were some pretty significant claims raised regarding placement based on sexual organs rather than identity. And that led to, severe consequences to the incarcerated who were subject to sexual assault and violent assault. It is also a consideration with respect to, enhancements to crimes, to revisit the Club Q shooting, the enhancements of that as a hate crime versus just charging it as its own non-enhanced crime. Obviously, this all, like many areas of law, has constitutional implications. There are First Amendment implications, religious freedom issues, parental rights. To the extent that parenting is a constitutional right, there are considerations with how to balance that and considerations with respect to protected classes, what can be regulated, what can be adequately protected without another constitutional amendment. And then you have other areas like employment law, where you're regularly dealing with protected classes, potential retaliation claims. And even outside of the scope of specific intersections with law, you have to consider the way you interact with your client and the client is presented within the judicial system. So the act of coming out and disclosing one's identity, it is not a one-time thing. You do not come out once and you're done forever. It is a process where you enter a new environment, assess the safety of that environment, assess the risk of disclosing your identity. You choose to share the identity or not, depending on what those prior assessments result in. And then you are left to process how people react to sharing that identity. And with something as emotionally and financially draining as a legal dispute, clients' comfortability with sharing their identity and with feeling heard and represented for whatever that identity is, that can heavily impact the outcome. If a client does not feel comfortable testifying on the witness stand because it requires that they be dead named, which is, using typically the name they were given at birth that does not align with their current gender identity or expression. If they have not legally changed their name, how do they contend with having that prior name repeatedly used? How do they contend with use of pronouns in these circumstances? And generally speaking, just how do they maintain the wherewithal to pursue a legal dispute through to conclusion? There are other considerations. Some of them we've been seeing progress on, as mentioned in Scott's introduction. When I was a program coordinator, I did a lot of work on the lack of protections for LGBTQ individuals within the Older Americans Act and the impact that has on those populations. When the Older Americans Act was reauthorized in 2020, there were some new protections included as part of that reauthorization. However, you know, one small victory is not reason enough to call it a complete victory. There are still some significant issues with barriers to access, with queer isolation. There is a breadth of research from medical organizations on the impact of isolation and negative health detriments, as we are seeing the LGBTQ individuals who survived the height of the HIV and AIDS epidemic. We are seeing a significant lack of access to community and some pretty significant isolation among those populations, in part due to financial barriers, in part just due to regional barriers, because there are not opportunities where they live and they do not have the resources to relocate, nor should they have to relocate simply to have access to care and access to community. There we go. And in terms of, you know, the next steps in advocating for clients effectively, there is, you know, this general kind of flow chart you want to keep in the back of your mind when interacting with clients and prospective clients, and you want to consider whether an issue is centered on their identity with respect to, you know, sexuality, gender identity. And if it is not directly precipitated on that, you'll want to consider whether their identity is a necessary or inevitable part of what is ultimately going to be addressed in the scope of a legal battle. And irrespective of that answer, I believe all practitioners should be making an effort to ensure they invite their clients to express how they want to be addressed. There are a lot of ways that you can do this. I think a pretty simple way to integrate this into routine processes so that it's something that becomes more natural and doesn't feel clunky or forced is to make it part of the intake process. If you use a standardized intake form, just including a section for clients' preferred pronouns, that is a great way to not only indicate to a client that, you know, you're a safe person to communicate this to because you were cognizant of it, but it gives you the chance to assess your own ability to address their needs and to make sure that you are not misstepping early on. Obviously, there are some other considerations, like many things, it's a catch-22, where you do not want to put a client in the position of feeling forced to out themselves. That is part of why I think an intake form is a great way to do this. They do not have to verbally communicate it, and they can choose to omit, you know, providing that information. And an intake form is something that is confidential. It's something they don't have to worry about, you know, ever being shared outside of the firm itself. So I think that's just a simple and streamlined way to kind of improve the initial interactions and help clients feel comfortable sharing that information. And it ties into the next consideration, which is how you ask clients for details and information without overstepping boundaries. Obviously, if a client seeks a consult and their issue is one specifically tied to their identity, so it is a discrimination claim on the basis of their sexuality, you are going to have those details from the outset. But if it is a situation where identity may simply be implicated, depending on what their identity is, it's something that you will need to know. It's one of those things you don't want to learn late in the case process. It's something you definitely would not want to learn as part of witness testimony at a court event. So again, I think this is where simple updates to processes makes it all natural and organic. I know, especially in the context of the work I've done since living in Colorado, I see a lot more inclusion of pronouns in email signature lines. This is one of those things that I think is beneficial insofar as normalizing discussions on it, normalizing the idea that it is safe to share preferred pronouns. However, people should also be aware this can create potential issues with respect to somebody feeling forced to out themselves if they put their pronouns in their bio. So somebody who is non-binary feeling forced to share that their pronouns are they, them. Somebody may have to deal with negative emotional impacts from misgendering themselves to avoid their pronouns becoming an issue. So while I see a lot of utility and long-term benefit to the way this kind of action has slowly become more normalized in recent years, I think people should be considerate of that, especially with the intra-firm level in mind, where you don't want to put employees in an uncomfortable position. Obviously, your clients will not feel obligated to share their pronouns in a signature line the way an employee might, but you want to make sure the environment you foster is a comfortable one, and that will generally bleed into the interpersonal day-to-day reactions and interactions where clients will get the innate sense that it is a safe and comfortable space. And that ties into the next point, which is whether or not somebody feels accepted or singled out. To the extent this information is relevant to a case, there will be times you have to directly demand this information and single someone out. But by and large, you want this information shared voluntarily to the extent it's necessary, because you want to foster that trust between yourself and your clients. And in terms of how these more modern understandings of identity fit into the courtroom, there is a lot of client management to be really cognizant of when dealing with these issues. For some judicial officers, it is safe and not a huge issue if you ask at the outset whether a client testifying on the stand or a witness more generally can be referred to as Mix, that is MX, rather than Mr. or Ms. Obviously, this may not be appropriate in every situation, so you should do your best to avoid having to use gendered pronouns. So just using terms like petitioner or respondent, appellant, whatever is appropriate to the fullest extent possible. And there has been a lot of judicial movement on this. A lot of JDF forms are being updated and implemented to include a voluntary disclosure of preferred pronouns. So I think for the most part, it's something that I believe we as a profession are seeing a more rapid change take place with respect to this pronoun and general terminology issue. And we should continue to keep that momentum moving forward, especially while we have, more favorable conditions in terms of current statewide mandates to be inclusive and considerate. So circling back, because these things all tie into intersectionality and their interrelation, it's really important to remember that gender and sex are distinct concepts. Sex is the biological and physiological distinction and, assessment of somebody's identity. Gender is the socialized manifestation, so it is based on the community you grow up among, how you receive and interpret information, and a lot of the policy in other states has a tendency to mix the two up. And in part, it has been somewhat beneficial because it has at least delayed implementation of regressive policy, because courts are finding that by conflating those two concepts, you are discriminating on the basis of sex. But to the extent something like a drag ban has to be argued as a First Amendment infringement, you want to be considerate of the fact that just because somebody may, dress in a way that's representative of the opposite gender, that does not mean they identify as that gender. There is a lot of variation. And while I wish the information I was providing could give some one-size-fits-all direction, there's nuance. We are human beings. Human beings are unpredictable and complicated, and we should always be very, very aware that, we are advocates and we have a duty to our client, and part of that duty includes making them feel comfortable in our scope of representation and making sure we are effectively representing them, which means addressing and protecting their own identity and comfort within the legal system. This is, pretty important. This is just the overview of what I was discussing, but you want to assess the viability of leading versus being led when it comes to these things. So in leading, you can do things like normalizing pronoun disclosure on a voluntary basis through intake forms. Being led would be allowing clients to choose whether to share this information. This would be something to be mindful of as you progress down the path of representation, because a client who shares a certain identity at the initial consult may become more comfortable throughout the course of representation and choose to disclose that they are actually transgender or would prefer this name be used, these pronouns. And all ties into managing client expectations and being sure they are aware of the risks they face with identity in the legal system and the extent to which you are able to protect them on that issue. Like most things in law, this requires information gathering. This is another overview slide, but you want to look at the issue. Is sexuality relevant to the claim? Is gender relevant to the claim? You want to discuss these things with the client. If either of those identities is relevant, you want to do this from a neutral and fact-based perspective, so they do not feel pressured to disclose anything, so there is no sense of impropriety in you broaching the topic. As I mentioned earlier, you'll want to discuss regional factors, and this goes beyond just a client potentially hoping to relocate. You want to think about whether a potential claim has more than one forum or venue where it can be raised, what the policies and landscape looks like in each, whether it may be more beneficial for a claim to be brought somewhere else because of that legal landscape. And as the legal advocate, you want to familiarize yourself with these things, and you don't want to put the burden on your client to educate you. Being proactive makes for an easier course of representation. And if you are proactive in educating yourself, it makes it easier to strategize and work with your client to address the best strategies for resolving claims within the scope of what's necessary. And there are more specific considerations. The regional climate plays in beyond just specific claims, as I mentioned earlier, in relocation cases. Even if things like a drag ban or other gender-specific legislation is not at issue, there is inconsistent application between the states of prohibitions on so-called conversion therapy for minors. Conversion therapy has been rejected by the American Psychological Association since, I believe, 1998. Most major medical organizations have rejected or otherwise debunked conversion therapy, including the American Medical Association. However, there are still several states that allow this practice to continue, where children are typically sent to an inpatient treatment program, and they experience, in essence, torture in an attempt to cure their sexuality or gender identity and keep them within the realm of the traditional binary cisgender heterosexual system. This is something that, really needs to be addressed whenever children could potentially be faced with being taken out of state for something like this. It is prohibited in Colorado to put children into conversion therapy, but if you are dealing with a relocation case and there is even a chance that could be something the child may face in the future, it's something you want to strategize, how to best put in front of a judge so they can consider that when making their determination. There are, frankly, a lot of financial limitations to consider when dealing with LGBTQ clients. There is, a broad volume of research on how early familial rejection impacts lifelong earnings. People within the LGBTQ community are more likely to experience poverty as adults, more likely for that poverty to be recurrent or cyclical. They are more likely to earn less than heterosexual cisgender counterparts. And this, by and large, is rooted in early familial rejection, where they are kicked out of their homes by parents based on their sexuality or gender identity. This means you should be prepared to direct clients to potential pro bono resources to the extent possible, and be as frank as possible about the scope of expenses that legal disputes can ultimately incur. There are mental health considerations. Mental health issues are more common among the LGBTQ community. Once again, this is something that has been linked to that early familial rejection, childhood homelessness due to familial rejection, and the cyclical poverty issues that also stem from that. So as far as you are able to address the potential impact of litigation or legal disputes generally with your client and how that might, be a burden on their mental health. If there are any specific considerations based on their identity, you want to address that as well and make sure you are managing your client's expectations and making sure they are taking steps to remain as mentally competent and capable as possible throughout representation. And because a lot of the legal changes happen on a state-by-state basis rather than at a federal level, there's a lot of unclear legal territory, and the fact that there are questions that maybe cannot be resolved until either a new Supreme Court ruling comes down on an issue or some sort of broader legislation is enacted. You need to be forthright with your clients about the scope of what's even possible under the law. Again, luckily in Colorado, there is a broader opportunity for recourse because we have more expansive legislation, but it's still something that should be discussed in a frank manner. And you have non-party considerations. So when you are representing clients in disputes where a non-party is implicated, so again, bringing up potential parental relocation, that includes children who are non-parties but whose entire lives are subject to either the agreement of the parties or whims of the court. And it is very important to be cognizant of that and make sure you are representing the potential impacts to the fullest extent possible throughout your representation. So in terms of resources and giving a summary, the Colorado LGBT Bar Association is always a great resource. The Center on Colfax is an LGBTQ organization that offers at minimum referral to legal resources. The Transgender Center of the Rockies has a 24/7 legal helpline, and they can direct people to further assistance. Out Boulder County keeps its own list of legal assistance for people dealing with issues involving their identities. And there is the Colorado Name Change Project, which is done a huge amount of work and made a significant amount of progress over the past few years. I believe they were incorporated in 2016. And since their incorporation and the first workshop they held, they have helped over 20,000 individuals pursue updates to changing their legal name and gender markers on government issued documents through in-person and online workshops. They have helped provide micro-grant funding to make this largely or completely free of cost to the people they help. And they've done a lot of advocacy work. So removal of the publication requirement for transgender and non-binary Coloradans seeking a name change, removal of the surgical requirement that for updating the Colorado birth certificate. Previously, you would have to have gender affirming surgery, which is not only a significant financial barrier, but something not every transgender individual would even want. That requirement is no longer in place, in part due to the advocacy that CNAP has done, or CNCP has done, sorry. There was a successful removal of the requirement that a district court order birth certificate corrections. There was the successful addition of a non-binary gender marker to Colorado issued identification and driver's license cards, and addition of non-binary and intersex gender markers to Colorado birth certificates. These are, incredibly important things that has helped put Colorado in its current position as a more progressive state with respect to these issues. And we, as members of the legal profession, should be aware of these resources, aware of their successes, and able to direct clients toward these. Even if a client's legal issue within your scope of representation may not implicate these things, if a client is seeking referrals or brings up an issue where they do not even know how to start with finding legal representation for that, being able to immediately refer to these organizations is a great way to not only build client trust, but build a rapport with these organizations through referrals and build your own reputation as an advocate that is mindful and conscientious of these issues. And in summary, overall, I know we're short on time and I would like to make sure any questions can be answered. If you make inclusive language part of your internal processes from intake through case closure, it becomes more natural, easier, and just a routine part. If you are proactive in managing your clients' expectations with respect to the emotional costs of legal disputes, that will go a long way. If you follow legal news briefs, and if you reach out to different bar associations, the CBA, the Boulder Bar, the Colorado LGBT Bar, other affinity groups, and you let them know you want CLE opportunities on issues more specific to your practice area, or more in-depth on certain issues, that is what's necessary to signal the need and to motivate these programs to be developed and held. And always be mindful of nuance. Everybody's different, and what works for one client may not work for another. But a good rule of thumb, especially as you try to incorporate these things into your day-to-day, if you make a mistake, correct it, but do not make a spectacle of it. So, language mistakes happen all the time. If you unintentionally refer to somebody as a she, but their pronouns are he, him, do not make a big deal out of apologizing and saying, I'm so sorry, I know these are your pronouns. Just correct yourself more naturally. So if you were to say, she took this pen, don't apologize, don't hold up the conversation's natural flow. So just say, he took a pen. Reiterate the sentence, correct the language, make it simple. Do not put somebody in the spotlight, because that shifts the burden. And I am now going to figure out how to stop screen sharing so I can check and see if there are any questions in the few minutes we have left. And I don't see any in the chat, which is fine. I know we are coming up on all of 5 minutes until 1. If you do have any questions that come up, you can reach out to me directly. My email address is kevinharlowmiller@gmail.com, or you can reach out to Kyle. He can point you in my direction. And as I mentioned, I will be sending Kyle the presentation materials, so the PowerPoint, as well as a fact sheet that has links to resources, contact information, and citations for the studies and data that I cited while I was going through this presentation. I really appreciate everybody's attendance and interest. I'm really thrilled at today's turnout. And, it makes me all the more glad to be part of the legal community in Colorado and to see that my colleagues are interested and care about this.
Kevin, this is Kyle. I see there's some thanks coming in via the chat. So I think we all would like to thank you for presenting today. This was great. And thank you again to Scott Hammers Law for sponsoring. We do have another diversity program coming up. It should be around November 14th. Judge Lindsay is working with our diversity chair, Sangeetha Malvarapu, to put on another program that'll carry an EDI credit. So between Kevin's program and Judge Lindsay's program in November, that'll be your 2 EDI credits for the year. So hopefully that'll help cover anyone who needs them. And again, as Kevin said, if you have any questions for Kevin that come up after the fact, feel free to send them to me. I will get them to Kevin or get you in touch with him. I'll send out the CLE form and the presentation as soon as I get it this afternoon. And I'll have the recording of this up probably by tomorrow, hopefully, or Monday at the very latest. And then if there was anything you missed or wanted to go back to, you'll be able to do so.
Great. Thank you, Kyle, and thank you all. I am going to sign off and get back to my workday. So everyone have a nice day.
Perfect. Thank you, everyone. Have a great day. Thank you again, Kevin.
Bye.
Thanks, Kevin.
Bye.